Congratulations, all my fellow pro-life activists in America, on this great victory. Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Oh yes, the Supreme Court yesterday corrected a 49-year-old error by overruling the expansive case of Roe versus Wade and the follow-up case of Planned Parenthood of Southeastern Pennsylvania versus Casey. But we have not won the war. We have taken a strategic mountain. That's all. Now that the mountain is ours, we can move on to other objectives, but those will be even harder, and we will win only with another great awakening. Before I begin, I do want to shout out to the sponsor of this channel, which is Conservative News and Views. Link in the description. And be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of good merchandise there, including this t-shirt I'm wearing, if you can read it, Rhino Hunting. All right, ladies and gentlemen, let's take stock of where we are and where we need to go. Now, first, I've left a link in the description to the decision in Dobbs versus Jackson Women's Health Organization. So many of our adversaries have read only parts of that opinion. We can't afford to make that mistake. Now, reaction to that case varies from the neutral to the overwrought. And you almost have to wonder why the overwrought. After all, whoever leaked Justice Sam Alito's first draft on May 2nd surely gave both sides plenty of warning. Nevertheless, half the country seems to be going crazy. Sources include CNN, NPR, and Vanity Fair. While CNN and NPR at least try to be neutral, Vanity Fair does not. Eric Lutz ran with this very bitter subtitle. I quote, "The court's conservative majority took a sledgehammer to reproductive rights in America, formally voting down federal abortion protection." Unquote, Eric Lutz. Now, Nina Totenberg and Sarah McCammon at NPR showed far more grace than that. In fact, they admit that law professors have long criticized Roe precisely as Sam Alito did in his majority opinion. CNN, to their credit, showed near total neutrality, but they also alleged that their polling shows that the public did not want to see the result in Dobbs. Now, they didn't show their work, so I don't know whether they're telling the truth or indulging in wishful thinking. But if those results are, as CNN says, we pro-life advocates need to know about them. After all, they show the hearts and minds battle we have to fight, and we already know that that is not going to be easy. Beyond that, well, I always leave a link in the description to an article that serves as a transcript. There you can see a series of embeds that show the most graceless and sometimes tone-deaf reaction from pro-choice advocates. These include video of speakers saying things that will only embarrass them later. Click through to the article and watch those videos carefully. We can use some of that material later. And in the meantime, it tells us their mindset. Most of this comes from a site called Pro-Life Update. Now, what can I say? I can understand that the ACLU lamenting that half the states will soon ban ending of pregnancy voluntarily. And they correctly observed that by overruling Roe, the majority in Dobbs removed the federal constitutional protection from that kind of procedure. I can and do question Senator Bernie Sanders of Vermont when he concludes that the American people want a different result. He may say it, and no rule of the Senate says he mayn't. That doesn't make it correct. But it ill befits a member of Congress to call openly for riots in the streets, as Representatives AOC from New York and Maxine Waters from California did. And when Maxine Waters calls for defying the court, perhaps even she can't say exactly how. More than that, she opened a door she might have wanted to keep shut. I'll say more about that later. And it certainly ill befits even a pro-choice activist to call for ending pregnancies because they expect the child to be handicapped, have Down syndrome, or be autistic. In point of fact, autism is still an acceptable ground for social discrimination and maybe the only one. In reply to that last, Liz Wheeler said it best, quote, "Those precious people have the same value as you and me." And it should have said you and I, but who's quibbling? I have embeds in that article to some even worse footage, courtesy of BizPac Review. I have to warn you, some of that stuff is pretty disturbing. Maybe you don't want your little children to see it. I will not describe them further, except to say that the common denominator in all these scenes is that pro-choice people started something and it got out of hand. But the pro-life side needs to ask not only where were those in authority, but how much of what we see represents typical attitudes in various places. Ironically, at least half those scenes took place in states where the law will not see any changes of substance. The rest will only infuriate pro-life legislators the more. Is that what they want? You decide. President Biden, for his part, put his foot into it. Yesterday, he tweeted out, and I quote, "Make no mistake, today's overruling of Roe v. Wade is the culmination of a deliberate effort over decades to upset the balance of our law. It is a realization of an extreme ideology and a tragic error by the Supreme Court," unquote President Biden. He also, according to Just the News, said the Dobbs decision makes the United States an outlier among developed nations. Wrong, Mr. President. The United States has been an outlier since Roe by reason of its permissive policies. The laws of most Western countries are far more pro-life than American laws today, at least pre-Dobbs. More embarrassing than this, another video has surfaced of Biden's remarks 16 years ago. He didn't seem to think the procedures we're talking about were really a choice or a right. He used the word tragedy to describe them and spoke of limiting the practice and keeping it safe but rare. You don't see that these days. That only goes to show you how far Biden and his fellow Democrats have gone. Go to the article. You can watch it there. Ramesh Ponnuru also picked up on how many Democrats originally voted for the Human Life Amendment during the Reagan years. In fact, that resolution cleared the Senate Judiciary Committee 10-7. Joe Biden was one senator who voted in favor, as the New York Times archives do show. Representative Nancy Pelosi of California, the Speaker of the House, left no doubt where she stands. She left a 4-paragraph statement, to which I have left a separate link in the description of this video, making several lurid predictions of what her opposition will do next. Then she said, quote, "The rights of women and all Americans are on the ballot this November," unquote. Well, that might be truer than she knows, because half the little targets for whose lives we're fighting are female. We pro-life people know this and are not afraid to say it. Speaking of targets, the late Ruth Bader Ginsburg has become a target of the left. President Obama apparently asked her to retire so that he could appoint somebody younger to carry her torch, and she refused. "I've got at least 5 more years," she said, as recently as 2018. Only she didn't. She died in 2020, and Amy Coney Barrett took her place. Scott Feinberg has perhaps the only reaction on the pro-choice side that's worth mentioning. Quote, "RBG was a hero to for many reasons. But the terrible irony is that her decision to stay too long at the party helped lead to the destruction of one of the things she cared about the most. Sadly, this will be a big part of her legacy, unquote, Scott Feinberg. Now, Mr. Feinberg didn't mention one other thing. Ruth Bader Ginsburg was afraid that Roe would fall exactly as it did in 1992 while lecturing at New York University, and I have a link to the description to a transcript of her remarks. She warned that Roe decided too much too fast. She didn't actually address any of Sam Alito's criticisms of it, but she did observe correctly that the Supreme Court decides most of its cases very narrowly. The court should, from her point of view, have invalidated the specific Texas statute making ending a pregnancy a felony except to save the mother's life. Ginsburg preferred the incremental approach that the left once favored until they must have lost all patience. And the Roe case simply galvanized the opposition, meaning us. Perhaps Ginsburg understood something today's detractors of her did not, and of which William O. Douglas lost sight when he wrote Roe. Namely, that if you throw a live frog into a boiling pot, he'll jump out. You have to heat the water slowly and gradually. Similarly, she decried the kind of language she saw already coming from a few court dissents, and not only the Supreme Court, but the courts of appeals as well. Specifically, she saw dissenters resort to name-calling, insults, and otherwise not exactly judicial or justicial language. Surely the dissent by Breyer, Sotomayor, and Kagan in Dobbs would have mortified her with embarrassment. Does that necessarily mean she really was as gracious as she at least pretended to be? Not necessarily, but it could mean that she was smart enough to know that you catch more flies with honey than with vinegar. Let's take a little break here. I want to shout out to another sponsor, BitNext. This is your replacement for Zoom, Slack, the Google G Suite, Microsoft Office 365, Dropbox, WeTransfer, and Chili Piper, among others. Unlike any of them, BitNext protects your content and conversations so well even the administrators can't see it. So this is your channel for secure comms, conferencing, cloud storage, and file sharing. Best of all, everything is back-end. You don't even need client software. If you have a browser, you can use BitNext. Scroll down all the way to the bottom, follow the link, give them a try. 28 days free of charge. You can't beat that with a stick. All right, we now turn to the pro-life reaction. Right off the bat, I have to give many of you credit for understanding what we have won and what we have not won. President Donald Trump, of course, took credit for yesterday's result, and President Biden showed no inclination to dispute it. It was all about the appointment of Gorsuch, Kavanaugh, and Barrett. The Daily Signal carried a pretty good summary of the opinion, the Roberts partial concurrence, and the dissent. Now, for their part, the Daily Wire remarked that many states will go all pro-life soon if they haven't already. To be specific, 13 states already have trigger laws in place. They're just waiting for their attorneys general and maybe governors to opine officially that these bans would face no credible court challenge. They are Arkansas, Idaho, Kentucky, Louisiana, Mississippi, Missouri, North Dakota, Oklahoma, South Dakota, Tennessee, Texas, Utah, and Wyoming. Now, of these, the attorneys general of Missouri and Texas have already issued their triggering opinions. And maybe others are doing it as I speak. 5 more states, Alabama, Georgia, Iowa, Ohio, and South Carolina, have laws on the books that courts have already struck down. Their attorneys general will now work to get them unstruck. Next, we see states ready to act, even if it means calling legislatures into special session to pass pro-life laws. Indiana is one. West Virginia left its pre-Roe pro-life law on its books. That goes back to 1848. They have now passed a pro-life amendment to their own constitution. Governor Glenn Youngkin of Virginia definitely wants the General Assembly to take up pro-life legislation next January. The Washington Post suggests that he'll ask for a law like Mississippi's Gestational Age Act, which sets a 15-week limit. But I must emphasize that I have seen no such statement from Governor Youngkin's office. Politico.com left an interactive page, to which I've left a link in the description, which tells you the status of the law in every state. Select a state from the drop-down list and boom, it will tell you about what the law allows and whether and how soon that will change. One thing that hasn't changed seems to be government attitudes in blue states. New York's acting governor signed new legislation recently declaring New York a safe harbor for choice. What exactly that new law will do is not clear, but the acting governor made her sentiments abundantly clear. Quote, "The women of New York will never be subjected to government-mandated pregnancies because that's what will ensue if Roe v. Wade is overturned by the Supreme Court." Unquote, acting Governor Kathy Hochul. Wow! Government-mandated pregnancies? Really? I think she's been reading too much Margaret Atwood. Even Justice Alito, in his majority opinion, said that's not going to happen. Justice Brett Kavanaugh said explicitly that the Dobbs decision does not make certain procedures illegal throughout the land. The reason is that there has never been a federal law about whether any kind of operation is legal or illegal. Pro-life activists and sympathizers, from Lila Rose to Bradley Dean, are the first to point out that the Dobbs decision does not make new law. It lets states make this new law if they will. And that seems to be the problem. How quickly will certain people act now that the Supreme Court seemingly has let them? Pastor Matt Trewhalla wonders just that. He said so in a video, and I've left a link to that in the description. Shortly after the leak, Pastor Trewhalla questioned why anyone would have obeyed Roe to begin with. Now that it's gone, he points out, we'll see who among ostensible pro-life politicians are actually sincere. Pro-life advocates usually, but not always, advocate for reversals of a few other Supreme Court precedents. The U.S. Solicitor General mentioned some of them. Griswold versus Connecticut, Loving versus Virginia, Lawrence versus Texas, and Obergefell versus Hodges. I've left a link in the description to a tweet that lists 3 of them and tells you what rights they provide. Now, I'll only say that Loving versus Virginia is not one of the 3. Now, that's the one that makes it unconstitutional to refuse a marriage license to a man and a woman of different races. Now, the court decided at least 3 of these precedents, I don't know which 3, I don't know about Loving, using substantive due process, which says that some liberties the government must allow no matter what process anyone employs to take them away. And Clarence Thomas wants to re-examine all of them. Well, maybe not the Loving case, because after all, he and his wife benefited from that. Justice Brett Kavanaugh does not agree. In his full concurrence, he assured people that the Dobbs decision does not touch those cases. So Clarence Thomas has at least a hard sell. His colleague Sam Alito barely held a majority together to overrule Roe. And he and Kavanaugh both had to assure in writing that their decision throws the debates back to the states. So if someone were to challenge some of those 3 precedents today, that challenge might not succeed. Tellingly, no other justice joined Clarence Thomas in his concurrence. The pro-choice side totally loses sight of that if tweets and other statements that they said do not be mentioned here bear out. The pro-life side should not, and I don't think they do. Now I have to say, from looking at the remarks from men like Matt Trewhalla, Bradley Dean, Gary DeMar, and Andrew Torba, the head of Gab.com, And I wonder whether they want to create a constitutional crisis, like Andrew Jackson defying the court over Native American settlement. They wonder why any state, including Texas, even dignified the Supreme Court with a filing in Roe. And in any event, the states should have defied Roe all along. Mr. Berger has made his decision, let him enforce it. Now that sounds bad, really bad. You know what? I think AOC and Maxine Waters opened the door. It was one thing when Keith Olbermann actually called for a dissolution of the Supreme Court after the ruling in the New York gun case. He can get away with that because he's a civilian. AOC and Maxine Waters are not civilians. They should have minded what they said. Now, I'm not saying that the kind of defiance for which men like Trewhalla, Dean, DeMar, and Torba seem to call would work, or that I would recommend it, or even that God would honor it. I do say that neither AOC nor Maxine Waters would have any room to criticize. I can criticize, they can't. Not after what they called for. But Justice Kavanaugh's concurrence gives the clearest hint yet of the real problem the pro-life side faces, which is we lack critical support for defining a right to life in the Constitution. At least Justice Kavanaugh thinks so. Clearly, he never even thought about whether natural law gives a preborn child a right to life or not. The Constitution actually is silent on the matter. It doesn't even define the word person. But when the Constitution is silent, then people and their jurists need to resort to a higher source. Some call that source natural law, but the source really has another name: God. America was once a Christian nation. John Adams, in his speech to the Massachusetts militia about a moral and religious people, said so. So in his day, men knew their Bibles well enough to quote from them and cite them in legal or constitutional deliberations. And when one does this, one finds instant support for our right to life in the Bible. Let me quote: "For you formed my inward parts. You wove me in my mother's womb. I will give thanks to you, for I am fearfully and wonderfully made. Wonderful are your works, and my soul knows it very well. My frame was not hidden from you when I was made in secret and skillfully wrought in the depths of the earth. Your eyes have seen my unformed substance, and in your book were written all the days that were ordained for me, when as yet there were not one of them." Psalm 139, 13 through 16, New American Standard. The problem is, these aren't the days of John Adams. These are the days of nearly a century and a half of government funding of schools that teach unbelief, for which I blame James G. Blaine and those who took his advice. Clarence Thomas did draw 5 of his colleagues to join him in repudiating the Blaine regime. That was the case of Carson versus Macon. But fully repairing the damage of those 147 years might take another generation or 2. So we pro-lifers must tackle the basic problem of a populace that has lost sight of its creator. In all of his masterful analysis of the relevant law, Justice Samuel Alito never once looked to the source. Neither did Brett Kavanaugh. I'm not even dead sure of Clarence Thomas, although I do know that he's a Catholic, like several of his colleagues. These men and women are products of their environment. The people must change that environment. That change will not come easily. But we on the pro-life side do have this key advantage. We believe in family and nurture. People on the other side don't. And they couldn't care less if the whole species died out. If they keep thinking and practicing that way, the species won't die out, but they will. Even before that, successive pro-life generations will outvote, outlast, and replace them. In the meantime, we fight as hard as we can, remembering that it took 49 years to get this far. Links to the description, to the article, to the opinion, to Speaker Pelosi's statement, to Ruth Bader Ginsburg's lecture notes, to the Political Interactive page, to Pastor Matt Trewhalla's video, to that tweet, to telling you what some of the other precedents are all about, and to conservative news and views. I have another link to the awesome online store and to BitNext, as I also mentioned. If you like what you've heard, you can like this video. And check out the subscribe link, my new playlist of all things Roe, and also my discussion of the Supreme Court repudiating James G. Blaine. This is Terry A. Hurlbut, delivering another declaration of truth and reminding you to let the truth set you free.